Welcome once again. Yes, we are still talking about the historical development of equity even in this video. Let's look at the conflict between common law and equity. The conflict between common law and equity. Recall that I mentioned in the last video that after the development of equity, we now have two systems of administration of justice, two systems of courts. Now, these two courts, they adopt different approach. Their approach differs. So conflicts became inevitable, unavoidable, irresistible. Most importantly, one of the major causes of this conflict between common law and equity was the use of common injunction by the court of equity. So the court of chancery, they use common injunction to frustrate the common law courts. For instance, they can issue the injunction to restrain a party from taking a particular action at common law. The Court of Chancery can also issue this injunction to restrain a party from enforcing a judgment he obtained at common law. So, common law judges, the common law court, saw that as a very serious affront. So, the conflict became inevitable. The conflict was illustrated by some cases. For instance, one of the cases is the case of Neat versus Ridley. Neat versus Ridley. In that case, it was laid down that where any matter was properly traceable at common law courts could prohibit the Court of Chancery from interfering in such matter. So that was the decision in Neat versus Ridley, that where a matter is properly traceable at common law courts, the court could prohibit the Court of Chancery from interfering with such matter. So that's one of the examples of cases that illustrated the conflict between common law and equity. So there were other cases too that illustrated these conflicts. However, one of the locus classicus is the Earl of Oxford's case. So the Earl of Oxford case is one of the locus classicus case, not even one, that illustrates the conflict between common law and equity. In fact, the conflict came to a climax in this particular case. It was this case was the last straw that broke the camel's back. So the Earl of Oxford's case is where the conflict came to an end. And the simple fact of the case relevant here is that the plaintiff was an assignee of a lease. The plaintiff was an assignee of a lease, and he built a house and had garden and other things on the land. Nevertheless, it was while his lease is yet to expire, was forcefully ejected by the defendant lessor, the landlord. Now the plaintiff brought an action at common law court for unlawful for unlawful ejection, but the court held in favor of the defendant that the ejection was lawful. Now the plaintiff now approached the court of chancery and asked the court to restrain the defendant from ejecting him from the land, and the injunction was issued restraining the defendant from ejecting the plaintiff from the land. The court of chancery issued the injunction. It was the case at chancery was decided by Lord Ellesmere. Lord Ellesmere issued the common injunction to restrain the defendant from ejecting the plaintiff. Lord Ellesmere stated that by the law of God, he who builds a house must live in it. So Lord, you can see what I said earlier, that the court of chancery, they were applying morality. So look at what Lord Ellesmere said, that according to that by the law of God, he who build a house must live on it. Yet the defendant in this case would have the houses, gardens and orchards which he did not build or plant. So that's what Lord Ellesmere said, that by God's law, anybody that builds a house should be allowed. You cannot eject the plaintiff after building, despite what you might say is the provision of the law, because the defendant was actually relying on the provision of the law. I think the Elizabeth statutes, but the court of chancery did not disagree with the position of the common law court. Ellesmere further stated that when a judgment is obtained by oppression, wrong and hard conscience, the chancellor would frustrate and set it aside. So Lord Ellesmere said that once a judgment is obtained by oppression, wrong and hard conscience, that the chancellor will frustrate such judgment and set it aside. Now, the common law courts were not satisfied with the decision, the interference by the court of chancery, more especially Edward Coke. Edward Coke protested. Edward Coke, who was the Chief Justice of the King's Bench, which was the common law court, protested that decision and asked the court of chancery to stop frustrating the common law courts. But the court of chancery responded that it was not frustrating the common law court, but that conscience, justice and conscience was in favor of the defendant. So Edward Coke made a determined effort to stop the interference of common law, the interference of the court of chancery, and it became a serious argument, disagreement, and conflict between the courts. Now, the conflict was referred to the king, as I said earlier, that the king always have residual power to do justice. So the conflict was referred to king, which was King James I. King James I. The conflict was referred, but King James II, this king, always delegating, referred the matter again to the Attorney General, Francis Bacon, Lord Francis Bacon, who held in favor of equity, that the injunction was properly granted, and his decision by implication was that whenever there's a conflict between common law and equity should prevail. whenever there is a conflict between common law and equity, equity should prevail. That was how the conflict between common law and equity came to an end. Now, the next important point is what now happened thereafter. Thereafter, because of this problem between the two system of administration of justice, something need to be done. And what was done? The next point is what was done, which is the fusion of common law and equity. So the next point we have to look at is the fusion of common law and equity. As said earlier, there were two systems of justice, two systems of administration of justice, and two systems of law, which are always incompatible, disagreeing with each other. The common law courts, which apply the common law, and the court of chancery, which apply equity. So there are two systems of administration of justice and two systems of law. And this poses serious challenge and problem to litigants, in the sense that before, for instance, if you are looking for a particular remedy, maybe if a judgment is given in your favor at common law court, and maybe damages is awarded in your favor, but you also need injunction, you have to go to the court of chancery. So you now see the problem. So it resulted to a waste of time and money. So it led to the waste of time and money by the litigant, and the system of administration of justice, or the procedure for litigation become cumbersome and unbearable. So there was the need for the fusion of administration of justice. So various attempts were made to fuse the administration of justice. Various attempts were made by the parliament. The parliament passed various acts trying to fuse the system of justice, or trying to solve the problem, but all to no avail, could not yield positive results. Now, in 1867, a commission was set up to look into the administration of justice. So it was now in 1867 that a commission was set up to look into the matter, and from the recommendations of the commission was the result of what is referred to as the Judicature Act of 1873 and 1875. So the Judicature Act of 1873 was enacted, and subsequently another Judicature Act of 1875. This Judicature Act now fused the system of administration of justice. So the Judicature Act fused the system of administration of justice. By doing this is what the Judicature Act did. It abolished the old courts and created the Supreme Court of Judicature, with a High Court divided into Queen's Bench Division, Chancery Division, Probate and Admiralty Division, etc., each of which has both legal and equitable jurisdictions. So this act abolished the court that were existing before, the court that were existing and applying different system of law, exercising different jurisdiction, common law court and court of chancery. They were exercising different jurisdictions before. So this act now abolished all of them and now created new court referred to as the Supreme Court of the Judicature, with various divisions. So the Supreme Court has various divisions, And the important point and interesting thing is that all these various divisions, they have both legal jurisdiction. Legal jurisdiction before was said by Court of Chancery, but this court, they have it. They also have the equitable jurisdiction, which before was exercised by the Court of Chancery. So that was how the system of administration of justice was fused, to the extent that a particular court now have the two major jurisdictions, which is the legal jurisdiction and the equitable jurisdiction. The next point is the effect of the Judicature Act. This Judicature Act, what is actually the effect of it? What is the implication? What the Judicature Act intend to do? Is it to fuse the system of administration of justice, or is it to fuse the system of law, or to fuse both the system of administration of justice and the system of law? So there were arguments about the effect of Judicature Act. Some say that the Judicature Act was the aim of the Judicature Act is to fuse the administration of justice. Some argue that it is to fuse the system of law, that is, to fuse common law and equity into one system of law, such that there will be no distinction between common law rights and equitable rights. All law will not considered as the same. That's the argument of some. But the correct position is that the effect of the Judicature Act is to fuse the system of administration of justice. That is, a particular court can now administer equity and common law. So the procedures is not longer like in the period before the Judicature Act, where you have to, if you are looking for common law remedy, you go to common law court. If you are looking for equitable remedy, you go to Court of Chancery. But now the same remedy, you can now seek it in a particular court. That's what that's the effect of the Judicature Act, and not to fuse the system of law. There is to merge common law and equity into one, as some argued. And now the statement, the metaphorical statement of Ashburner is very apposite, is very instructive as regard the effect of Judicature Act. So let's hear what Ashburner say about the effect of the Judicature Act. Ashburner stated, the two streams of jurisdiction, though they run in the same channel, run side by side and do not mingle their waters. So this is what Ashburner stated about the jurisdiction, the effect of the Judicature Act, that the two streams of jurisdiction, they run in the same channel. The legal and equitable jurisdiction, they are now running in the same court, but their waters, which is the law, the rights, equitable rights and legal rights, are still distinguished, are still separate. There is still dichotomy between legal and equitable rights. The only thing is that they cannot be administered in the same court. And there are some cases that illustrated this effect of the Judicature Act, that illustrating the fact that the two systems of law were not fused, but the system of administering the procedures for administering them is what was fused, and not the law. And one of such cases is the case of Walsh versus Lonsdale. The case of Walsh versus London illustrate the fact that the system of law, the two systems were not fused, because in that case, a particular transaction, a contract which under law would have been unenforceable, in fact was illegal under law, was upheld in equity, It was a case of an agreement for lease where the landlord and the tenant entered an agreement and for a lease for 7 years, and under law such agreement for lease for 7 years has not been made, so in fact it is illegal. And under the agreement for the lease, it was also stated that the landlord could demand a rent in arrears, could ask the plaintiff to pay rent in arrears, that if the landlord so demand, the plaintiff will comply. But when the landlord demanded the plaintiff to pay, made the demand, the plaintiff refused to pay. Sorry, not to pay in arrears. The agreement was that the plaintiff could be asked to pay rent in advance, rather, not in arrears, in advance. So it was agreed that if the landlord demanded rent in advance, the plaintiff will pay. That was the agreement under their agreement for the lease for 7 years. Now the plaintiff actually went into arrears, and the landlord demanded for payment of rent in advance, which the plaintiff refused to pay. Then the landlord distrained the plaintiff, and the plaintiff brought the action for illegal distress. Now, what the transaction between the plaintiff and the defendant was an agreement for a lease, that the plaintiff will grant a lease of 7 years. The landlord will grant a lease of 7 years to the plaintiff. Now, this lease has not been granted. So, what is important now is that term that if the landlord demand a rent in advance will be paid, ordinarily wouldn't have been enforceable since the lease has not actually been granted, and that transaction at law is illegal. It was illegal because no lease for 7 years had been granted at law, so it was an illegal transaction. But the principles of equity was applied in that case to hold in favor of the landlord. The principle was that an agreement for a lease is as good as lease. So the court held that agreement between the plaintiff and the defendant, which is the landlord, for a lease is as good as lease, and they are in the same position as if the lease had been granted. That the plaintiff and the landlord, the defendant, they are in the same position as if the lease has already been granted. So there's equity for you. Equity stated that agreement for a lease is as good as lease. So equity considered as if the lease has already been granted, so the terms of the lease can be enforced, and the terms of the lease has also come into operation, and it was held that the plaintiff should pay the landlord the rent in advance, because they're in the same position as if the lease has been granted. So there's showing that the principles, rules of equity still intact, and the principle of rules of law, they are still intact. The two systems of law were not fused. So even still today, we can still see the distinction between common law and equity. that, for instance, we still have equitable remedies, and equitable remedies are granted on their own principles. Essentially, equitable remedies are granted by the discretion of the court, but a remedy at law is granted as of right. Is granted as right. So this showed that the two systems of law were not fused, but the administration of justice was fused. So that's the effect of the Judicature Act as illustrated by Walsh versus Lonsdale. Now, it's remaining one point to end this history of equity, and I would love that to be the last video on this historical development of equity. So we shall end here, we shall stop here in this video. So see you in that video. Thank you.